We can confirm if Commissioner Corn can hear us.
Yes, you are now.
Good morning.
I can now. Thank you.
Commissioner Corn, you appear to have two connections to Zoom for this meeting.
Yeah, the laptop is not set up properly and I can't get the audio to work on it. So I was just going to use it for visuals unless that causes a problem.
So far, I think you're good. If you can mute the laptop, the speaker, just be sure you don't end up with a feedback loop. It might be helpful. But so far it sounds okay. I don't think it's an issue.
Okay, let me know if it is.
Okay, thank you.
Thanks.
Okay, staff's good.
Okay, 1 second.
Can I ask a question here before we start? Because I did tell Lewis I was going to bring this up. Does the board want legal present so that we make that decision in hearings? Because sometimes we say yes, sometimes it's really a no. That way legal can be freed to work their backlog of stuff that is piling up. And so it's reasonable. If anybody wants it, we should keep it. Keep them present, but if we don't think that we have a question for legal, if we could let Nate return to the prosecutor's office. So
Yeah,
I'm
that's a
just
great
asking
question.
that.
Commissioner Corn, would you like legal present?
I would, in case we do have anything. I don't foresee this thing taking a whole lot of time, but we'll see.
Okay. All right, with that then, it's 9:03 a.m. on October 29th, 2025. We call to order this public hearing. We have only one file to hear this morning, file ZC 0003-25, zone change rural 10 to rural 5 as a reconsideration. We'll begin with any conflicts of interest on the board. Commissioner Corn?
Commissioner Corn has none.
Commissioner Williams has no conflicts.
Commissioner Domke has no conflict of interest. All right, we'll turn it over to staff.
Thank you, Commissioners. Kyle Snyder, Bonner County Planning Staff. I was going to ask, do the Commissioners want to hear the staff presentation again, or would you like to just move into the applicant's presentation?
Commissioner Corn, would you like to hear the presentation again, or can we move into the applicant's reconsideration request?
I am fine with moving on.
Okay, Commissioner Williams.
I cannot recall how we said this was being reheard as to whether or not this was needing to be on the record for this hearing. So I would defer to what planning would say on whether or not it needs to be presented in this hearing.
Alex Fan, Interim Planning Director. So I spoke with Kyle this morning and nothing has changed in the staff report from the first go around. Everything would be included on the record if this were to go any further. So everything that has been written up to this point would be included in the record. So if the board wants to hear it again, just as a refresher, Kyle's prepared to do that. But if the board feels that they're comfortable with the staff report, then you're welcome to move along to the applicant representative.
No worries. Then my vote would be to move on to the applicant.
Okay, then we are not going to request to hear
Excellent.
the staff report again. Thank you for offering. And we will open it up for the applicant to offer their reconsideration request.
Jeff Wiley, 594 Hidden Valley Road. I'd like to thank the board for considering the appeal, and Matt Linscott has agreed to help me in this process, and he will help articulate our concerns of the previous decision. I've been a licensed land surveyor for over 40 years. I prepared 2 maps that hopefully will aid in your decision process, whatever that may be. The slope exhibit that I've attached, is that in the files or something? So you can see that?
Yes, the staff report for the reconsideration hearing for this hearing includes those documents.
Okay, the slope exhibit is an attempt to quantify the different grades on the existing parcel. And the break in the 30% area on the south side of the seasonal drainage is likely a road cut from, an ancient road cut from the days of Humberg lumber. The proposed split exhibit is showing where the split would be acceptable by county design standards. I mean, it might deviate slightly, but I think basically there's not a lot of choices to make it work. And that's how we develop the lots. The place we have the housing right now, to me, is the logical area because the whole part of this property that we even purchased it 30 years ago was the inside track of that seasonal drainage opened up a little quasi view area in the property, and we look across the whole property. And the main reason that I began this process last March is that my daughter Jackie asked if she could purchase her home, which she lives in the ADU on her property, and the front 5 acres for my wife and I, and that would help us in our retirement. And her 2 children, our granddaughters, have spent most of their lives on or around the property. Thank you for the consideration.
Thank you, sir. Mr. Linscott?
It's all right, I might bring the microphone up here, I have some handouts and stuff. Matt Linscott for the record. Think like Mr. Wiley said, thank you for this reconsideration. We're pretty much here just to discuss 2 items. And one is the slopes and the other one is the soils. As we're looking at the board's findings on the prior hearing, it appears that those are the two items that we need to go ahead and address. 12.323 states that the property has to be characterized by slopes that are steeper than 30% for it to fall within the R10 category, as well as containing agricultural soils. I have these, so I might as well just give them to you. So,
Can we pause for a second and let Commissioner Korn know what you handed out so he can pull your document up that you handed out if you wanted to?
yeah, sure, Mr. Korn, we gone ahead and handed out copies of Bonner County Rise Code 12-323. And that's the section that decides, for the rural designations on whether it's going to be zoned as R10 or R5. And the 2 criteria that the board found prior was that the parcel had the presence of prime agricultural soils, and then there was a presence of slopes on the property. The actual code doesn't use presence, it uses the words characterized by slopes steeper than 30%. In that same document, 2 lines down, it uses the word presence for agricultural soils, for prime agricultural soils. There's a difference between characterized by and slope steeper than. Characterized, from what I have found, it means the describing, distinguishing trait or quality of something. Replacing characterized by presence would be a policy change that was not adopted through ordinance. And while the board may interpret its own code, it may not amend by interpretation. As the Idaho Supreme Court held in Ada County versus Gibson, because zoning laws are in derogation of common law rights of free ownership and use of property, where more than one reasonable interpretation is possible, the interpretation that places the least restriction on the use of the property is favored. Mr. Wiley, a licensed survey, has gone ahead and made the map, and it shows less than a half an acre is 30% and steeper on the property. I didn't know if I can go ahead and pull that map up here, because I don't know if the map that Mr. Wiley submitted to you actually included the certified stamp. I don't know if it did. I think it did. So here's the 10-acre piece, and Ron, Mr. Korn, I'm showing them a map, what Mr. Wiley gone ahead and done since he's a licensed surveyor. He gone ahead and mapped the slopes and has the legend where it says areas containing slopes of 30% or more.
Mr. Linscott, would you pause, please? Commissioner Korn, this is the last page of the staff report for reconsideration. It contains the same map that's being shown to us in printed format, just so that you're able to observe the same information.
And so as you can see on the map, the 30% and steeper portions are down here next to a seasonal stream, runoff stream that goes through the property. The property is not bisected by steep slopes. There's an existing road, and I have photos I'm going to show you next. There's a road that continues down from the house, down across the creek, and then up to the southern portion of the property. It is not completely bisected by these slopes in the seasonal stream. Recent board approvals have recognized that if slopes do not divide the parcel, that factor should not be preventing the R5 zone. Allowing some parcels meeting the same criteria to receive approval while denying other raises equal protection class of 1 claims. And there's many cases to that effect, primarily in the U.S. Supreme Court, Idaho Supreme Court, and Ninth Circuit Court. Now, I'll go ahead and read those here in just a second. There was, if you're concerned about, I was going to go into the pictures next. These are photographs that we've gone ahead and took, and this is a photo looking across from the stream. So this photo is going to be taken just about in this area right here on the map, and where I'm pointing, Mr. Korn, is across the stream on the southern portion of the stream where that road goes up through and into the southern portion of the parcel, and that's where this is sitting. And so you can see here, this is the main house. Here's the driveway right here. Here's the stream bed right here. There's already a road across the stream bed. And like Mr. Wiley said, that was more than likely, that original road was probably put in during the Humbert days when they were in there logging the property. Here's another photo on the southern side, and this is a road that goes across the stream. There's a big culvert there, and it's not steep at all. You can probably take a golf cart from the northern portion all the way up through into the southern portion of the property. There's a third photo, kind of the same area. This photo here is actually taken on the north side of the property. This is going to be sitting just about right down in here, and it shows the terrain and the topo here on the north side. The stream is flowing right through here. You can kind of see there's an old wooden footbridge across that little stream. And then this is the southern portion here. The embankment there was created more than likely from that stream, that seasonal stream that goes through there through the decades. And you can kind of still see some of the old burnt stumps from the old 1910 fire that kind of went through a lot of this area. But it's not like a hillside. It's just where the embankments are. Here's a photograph once you cross there. Mr. Wiley had done a lot of cleaning up on the property. There's road trail systems all the way through here. And like I said, you literally could leave from his house and take a golf cart if you wanted to and traverse the entire area with it. It's not steep at all. Here's some more photos from the southern side of that slope. Here's still on the south side, kind of looking north back towards the house. Here's one also from the northern side looking back. You can kind of see in here, you can't see it very well, but this is from the northern side of the house, and then this is the southern side right here, and this is where that seasonal stream cuts through, is in between there. And then this is on the southern portion. Like I said, there's trails all across there where people can go ahead and use for hiking, cross-country skiing, or whatever was being used there now. The geotechnical analysis, which is adopted in Bonner County, it was in 2022. We reference it as a geotechnical ordinance because that's what it done. What we created is When land disturbing activity is proposed in areas where natural slopes equal or exceeds 30%, the planning director, hearing examiner, zoning commission may require conceptual engineer plan as part of the subdivision, condition use, or variance. The plan shall be developed by an Idaho licensed civil engineer and shall depict proposed building sites, roads, and driveway grades, profiles, and cross sections, and the slopes, location of cuts and fills. The purpose of this plan is to demonstrate the feasibility of the proposed subdivision design, to illustrate the nature and extent of earthwork required for site preparation. This is for the purpose of this was to go ahead and protect the community from loss of lives and property and reduce public and private financial losses due to slippage. Here's a copy of that geotechnical analysis. So when we got ahead and the county got ahead and drafted 12-323, that was in 2008. This was drafted in 2022. And the reason for that is so that people could still go ahead and develop on slopes. And we want to make sure we had the box check for health, safety, and welfare on those steep slopes. So I believe, this is one of the reasons why at the planning commission level, we did not recommend for the difference between zones. We took slopes and soils both out because we felt that this goes ahead and covers that checkbox for health, safety, and general welfare. Moving on to soils. In the staff report, they said there's approximately 2 acres of what they refer to as cell emission complex, Unit 50 soil. But neither in the 2000, let me back up just a second here. Again, 12-323 was adopted in 2008. This is the comprehensive plan in the draft language from 2005. So this is the backdrop to that. And for prime farmland soils, I think I have 2 copies here. It states that approximately 65,565 acres meets the soil requirements for prime farmland. But if you flip that page, I don't know if you can do that.
Can you clearly state what it is so that Commissioner Korn can follow along with what you're handing out?
Yeah, what we're looking at, Mr. Korn, is Chapter 3 of the 2005 Comprehensive Plan. It's titled Chapter 3 Soils. And it goes in Section 3.1 and defines prime farmland. And it says approximately 65,565 acres of soils requirement meets the requirements for prime farmland. But if you look through there, then in the very next page, it gives the soil classifications as far as class. Cell emission complex is a class 4 soil, which the definition is soils have very severe limitations that reduce the choice of plants or that require very careful management or both. And then the very next page, it goes into prime farmland map units. And it gives, I think there's nine soils that are considered prime for Bonner County. Cell emission complex is not located in there. In fact, on the next page, it goes into non-prime farmland map units. And if you turn, you have to go through a couple pages there. You're going to see soil map unit number 50, which is a cell emission complex. It is classified as non-prime farmland in that 2005 comprehensive plan. Then if we go ahead and the very next page, you can actually go to the 2022 Bonner County soils, and we just updated the soil list. It also has 65,518 acres. And in that soil map unit, 50 is not listed, and that would be right, it's going to be in the very last page in here. And soil map 50, cell emission complex, is not listed as prime farmland. And perhaps maybe most importantly, when we got ahead and adopted Title 12, that was through Ordinance 501, because in November 18th of 2008, Bonner County repealed in its entirety all prior Title 12 and adopted a new one on that date through Ordinance 501. Through Ordinance 502, we got ahead and adopted the zoning map. And with this map, And I have the full map here. With this map, here is the legend for it, where we actually gone ahead and put on this map prime egg soils on this property. Here's section 25, where Mr. Wiley's property is located. There are no prime egg soils in 25. And that's because we only listed the prime egg soils in there. We didn't list prime egg if drained, prime egg if irrigated, because they're not true prime egg soils. So this was adopted through ordinance 502, and that's still, to this day, the official zoning map. You know, in 2020, in 2022, we gone ahead and adopted ordinance 680, which amended Bonner County Code 12320, and it states, the official zoning map shall be made available in electronic format for the public to view. That's all it did. When we gone ahead and adopted ordinance 680, which I have a copy here if you would like to see it, we did not repeal, amend, or anything with ordinance number 502. That is still the official map for Bonner County. And there again, it does not show any prime egg soils on the property. Moreover, if NRCS states in 622.03 clarifies only drained areas meet prime farmland criteria, but no such systems exist in 25. In Bonner County, we don't have, there's a drainage district down towards Commissioner Williams' direction off of Highway 41. That's the only drainage district we have in the county, but there's nothing in 25. Also, the NRCS General Manual 402.6 states, soil surveys seldom contain detailed site-specific information and are not designed for use as primary regulatory tools in site-specific permitting decisions. This is important. It's a disclaimer. It's their best guess to it, similar to the wetlands mapper. And we've seen that many times where the wetlands mapper will show wetlands and they haven't delineated, and it's not. It's their disclaimer. Also, when you go to our own mapping, our own GIS mapping, before you're allowed to go ahead and even look at that maps, you're going to have, I'll give this to you here. This page pops up. It is a disclaimer. And it says the Bonner County government provides this interactive map and associated data as a public service. We hope you find the application useful, but if you use this data, you need to know that it does not represent survey level accuracy and contains errors. The county makes no claims to the quality, accuracy, completeness, or timeliness. Maps and the associated data are for illustrative purposes only. County does not accept any responsibility for loss or damages arising from anyone who may use this information. Please refrain from acting independently based solely upon the information shown here. Users should verify any information with the county official records before acting upon it. And you have to click the agree button to that disclaimer before it even lets you proceed. Those maps are they're very general. They were not created to be horribly accurate. They're disclaimers from the NRCS, NHSS handbook, even our own GIS map shows that. But I think the most important thing is that adopted and still official zoning map shows no prime agricultural soils in section 25, because Silly Mission Complex is not a prime soil, as demonstrated through the list in the 2005 comprehensive plan and then updated in the 2022 list. Soil map unit 50 does not exist. Even the, going back to that disclaimer, in the general manual for the NRCS, it states, soil surveys seldom contain detailed site-specific information and are not designed for use as primary regulatory tools in site-specific permitting decisions. I think we demonstrated that there are no primate soils on that property. Here is the...
Can I just ask for a pause here? Because usually we're putting a lot out here. They're supposed to be numbered at the time. Are you going to We have to identify what's being handed here so it goes in the record.
I can't number them, I suppose.
Okay, so we're gonna put it.
They're all gonna have to get
Yeah.
either scanned
'Cause I don't wanna
or
miss,
turned in for the record.
their-
So are you okay with whatever map you're about to, it looks like an older,
Yeah, it's the
That
only
was
one I have.
Where I was going
But-
with your original, that looks very antique, and
Well-
this stuff looks printed, and
Yeah. and
you're
what-
giving, if, before you show it, you're giving this as part of the record, so it stays here if you open it.
Well, what it is it's just a blown map of, and this shows the,
I'm just saying, pick your delivery if it, if you.
well, I'll pick this.
if-
I'll hold
okay.
on to my map.
That's where I was going, is
You are
you
so
don't get it
forewarned.
back.
Yeah, I just, it's photocopies of this map. And on this copy here, it shows the ordinance and adoption and instrument number. Here's a copy of section 25 showing no prime egg soils. Like I said earlier, there was a couple files, actually, I believe there was 3 of them. One was up on Jenkins Road, one was on, the most recent was on Cross Road, the other one was for property owned by the Feist down in section, Township 56-2 West, where they all had shown 30% or more slopes on those properties, and all those files were approved. Because and the reason for that, because they were still able to be split and have home sites on all the parcels that was shown. Mr. Wiley's map he has there shows how the 5 acres is going to be split. There's already existing homes on there. It's for his daughter and grandkids who live in the property. Touching on that whole, we have to go ahead and be consistent with how we're interpreting code. And it's called equal protection. And the county's discretion is still bounded by the Equal Protection Clause found in the 14th Amendment, Article 1 and 2 of the Idaho Constitution. The U.S. Supreme Court's authority, Village of Willowbrook versus Olick, and this is a quote, "Our cases have recognized successful equal protection claims brought by a class of 1 where the plaintiff alleges that she has been intentionally treated differently from others similarly situated, and that there's no rational basis for the difference in treatment." In Allegheny, Pittsburgh, Cole versus County Commissioners, this is another U.S. Supreme Court case, the clause requires rough equality in treatment of similarly situated property owners. City of Claiborne versus Claiborne Living Center. Denial of a land use permit based on irrational prejudice violates equal protection even under the deferential rational basis test. In Yick Woe versus Hopkins, the equal protection of laws is a pledge of the protection of equal laws and is violated when neutral policies are applied unequally. The Ninth Circuit Court, Gerhardt versus Lake County. A county's denial of a road approach permit where neighbors' owners received approvals under the same conditions supported an equal protection claim. Under Idaho authority, Medical Recovery Services versus Strawn. The principle underlying the equal protection clauses is that all persons in like circumstances should receive the same benefits and burdens of law. And so I think we demonstrated there are no prime egg soils on this property. I think Mr. Wiley's slope map demonstrates that the southern portion can be accessed. There's an existing road. The photographs show that. The property is not characterized. There's less than an acre that is 30% and over. But we have to also remember that our code states that it has to be over 30%. And so on the map that Mr. Wiley produced, it's 30% and over, but our code says it has to be over 30% and it has to be characterized by that. That seasonal stream going through that property, it's like I said, it's not a hillside. It did not create a hillside. It's a stream bank, and that's all it is. And do you have any questions for me?
I don't have any questions.
Commissioner Korn, do you have any questions for the applicant?
No, thank you, Mr. Lynn.
Can we start you on your task of labeling your stuff? I have a pen right here for you.
We're going to go into public comment. Do we have anyone in favor of the application that would like to offer public comment in the room? Do we have anyone online that would like to offer
I don't want it
public
to
comment in favor
get
of
out
the
of-
application?
paperclip.
Okay, do we have anyone in the room neutral that would like to offer public comment on the application? Do we have anyone online neutral who would like to offer public comment on the application? And finally, do we have anyone in opposition to the application in the room that would like to offer public comment? And do we have anyone online in opposition to the application that would like to offer public comment? Well, we've had no comment. However, the applicant does have the opportunity for a rebuttal if you would like. Okay. It's your choice. I know we didn't have any comments, but okay. With that, then, we're going to move into board deliberation. Commissioner Korn, would you like to make any comments or statements with regard to deliberation on the 3 topics that have been presented for our consideration under this reconsideration hearing?
Yeah, so listening to the appellant makes a very good argument and has provided plenty of documentation. It looks like I didn't get to see all of it, but I'm following it the best I can. The soil listing complex that takes up approximately 20% of the property up on the corner is not prime agricultural soil. I don't see where it's demonstrated that it is. So I would have to take that out of the Rule 10 standards. And then dealing with the slopes, I would agree that it's not characterized by 30% or more slopes. It has some, and it sounds like it is that seasonal creek bed, which exists in many places. So I would say that it exists, but is not characterized by 30% or more slopes. So therefore, taking those 2 things out of the equation, it does not meet the Rule 10 standards, which by definition does meet the Rule 5 standards if it does not meet the criteria for R10. And I find that I thank Mr. Linscott for that information because I think we need to include those maps and those ordinances in the future up until the point where the new plan is adopted to where we don't have to deal with slopes and soils anymore. And I think that would be a great time when that time gets here because we're dealing with too many unknowns. Even the map is not accurate, which has been proven to us in past cases when the applicant has brought in actual soil tests and proven our mapping to be incorrect. So at this time, I don't see any reason why we should not allow the zone change from Rural 10 to Rural 5.
Thank you, Commissioner. Commissioner Williams?
So there's some things that were stated that I kind of reject. Prior boards making a decision doesn't mean that I'm bound to make the same interpretation, and especially when it comes to the idea of characterized by slopes, there's an inherent problem with using that language that we've used as a county because it makes it open to the interpretation of the individual, and I think that the board is addressing the consistency in how decisions are made by the way in which we're making the decision. So I don't see that as an argument. What I do see is the question of so for me there are slopes. There's an interpretation of what does characterized by slopes mean to an individual that's taking a look at property. When it comes to the zoning map, when we're talking about what exists, there has long since been a competing conversation of, is it that every property within the zone contains this when there's an equal kind of understanding that we don't go through and measure on every piece of land on every area for something, or is it the zone is identified as a prime ag soil? But barring that, Mr. Linscott's question of the specific soil type that's labeled in the staff report being identified as prime ag soil. Is that, I'm going to ask staff on that question, because if staff is saying that what they identified as prime ag soil, are you conceding the argument to Mr. Linscott that it is in fact not prime ag soil, because in this particular staff report, it calls out that as being prime ag soil. And so, can I ask you your position, having heard what he has said about that? Would you say that that is accurate, that that soil is not deemed prime ag soil?
I would not agree with that. So from the, excuse me, from the currently adopted natural resources component that we have, there's a list of prime, so we call them prime ag soils in the zone.
Can you identify yourself?
Oh, sorry. Alex Fan,
Thank you.
interim planning director. So we call them prime agricultural soils, but we refer to them as prime farmland, as does the NSGS. So there's always been the toss-up between there of whether they're synonymous with each other or not, and we always have assumed that they are. But in the currently adopted natural resources component, we have areas that are considered prime farmland, and prime farmland includes prime farmland if irrigated, prime farmland if drained, and prime farmland if irrigated and drained. I don't remember
If
off the top of
drained
my head.
and protected from flooding or not
There we go.
frequently flooded during the growing season.
There we go. And this one is this Selly Mission Complex, or Selly Mission Complex, tagged as number 50, is considered prime farmland if drained.
Okay, I appreciate that explanation. And in part, when I'm deliberating on this file, part of our mission as a county is to protect that opportunity. It doesn't mean someone is required to do it. It means that that's what we're supposed to look at in considering dividing out that kind of land. And so for me, if it contains that soil, it meets, because you only have to meet one. It doesn't say you have to meet all. So if we remove the argument of the whose interpretation of characterized by slopes doesn't change that it does have that soil, then it meets a condition of 10. And do you divide it? And that, for me, would be if I were to receive guidance from staffing that said, this is why I would say this is one direction or another, and I had to remove the soil aspect, I could see the toss-up between slope, characterized, it's an interpretation. What is the negative of changing from 10 to 5? Because the map that was presented as evidence, there are slopes that are at or above 30. I assume, and this is an assumption, that if you're given the argument that it needs to be greater than 30, that the lines that were presented on that map should be what's greater than 30, because that's the argument of what is characterized by. And the argument presented was it's not characterized by that. That's open to interpretation. But if the staff report is going to hold to the comment about the soil type, then it meets a condition of 10, which means it can't go to 5. And the question then to the board is, do we accept the argument presented by staff on the soil type, or do you accept the argument that it's not? And I can accept the desire to change it, but if that soil exists, it meets, at a minimum, if I remove the questionable one, it meets an element of Rule 10. So that's where I am on it. It's not just, and I can't say that if we decide something different than the board in the past, that means that I'm wrong or I'm obligated to someone else's. It means that if people didn't like the rationale given, then they should have appealed it to the court. Similar to what happens here. So that's kind of my discussion topic on it. I'm not going to pretend to be an expert on the dirt, so I'm listening to another opinion on it, but if that's what staff is identifying as an element, and I guess I could be even more direct, is given the answer, Alex, that you've given, you find the condition is met for, that's listed in our table, because I also want to address, there was a comment of whether or not it was present. It doesn't, in the table itself, on 10 to 5, it doesn't say anything other than the word contains. It says contains. So is it the position of planning that it contains, I want to say it right, that soil type?
To the best of our knowledge with the resources that we have, yes.
It says contains prime agricultural soils. So it would mean that based on the information the county has, that it meets an element of 10. Okay.
Correct.
I'd like to ask staff a question, if you don't mind.
Go ahead, Commissioner.
So, Alex, could you explain to me why the discrepancy between what you're claiming that wherever the information is coming from, I didn't catch that, showing that there's 2 acres of this prime farmland if drained. I'm not questioning the map. I'm questioning the context that it sounds like the planning department is taking the stance that it is prime agricultural soil, and yet Mr. Linscott has presented some type of a map that I wasn't able to see, showing the section that this parcel fits in, or section 25, it sounded like, that contains no prime agricultural soil. So can you try and explain to me where the discrepancy seems to be coming from? Like I said, I wasn't able to see the map that was presented, so I don't know what that looked like.
Okay. I'm not familiar with the exhibit that Mr. Linscott provided, but I can tell you where our data came from. So our data came from the GIS map. When reviewing the parcel, it showed 3 different soil types, 2 of which were not prime farmland and 1 that was. And when we reviewed it in the natural resources component, which contains all of the soil types in the county, at least the ones that have been listed by the federal government, it was included that Selly complex, mission complex, was included in prime farmland as designated by the federal government.
Commissioner Corn, I can help further answer that question. That was going to be a part of my presentation with deliberation. So if you'd like, I'll touch on that as well.
Thank you.
So the historic, I'll call it, prime farmland soils map that was presented by Mr. Linscott, that only identifies areas that are designated as prime farmland. It does not include prime farmland if irrigated, prime farmland if drained and protected from flooding, with that larger caveat. So there's 4 categories. Only one is contained, only the best one is contained, if you would, on that map. There's also the table in the natural resources component that lists certain designations of soils. That limited number of soils in that table are also only prime farmland soils, not the other 3 categories. The issue is, in my mind, that if we are going to follow our rules, our code and our comp plan, the natural resources component of the comprehensive plan that was adopted last year in 2024, so it's our most current adopted version, section 3.2, titled Prime Farmland Soils. In that section, it says, in accordance with the Code of Federal Regulations as noted above, NRCS designated prime farmland soils in Bonner County. The designation of prime farmland soils is based on the limitations imposed by irrigation, drainage, and flooding. The designated categories of prime farmland are: all areas are prime farmland if prime farmland if irrigated, and prime farmland if drained and protected from flooding or not frequently flooded during the growing season. So because our comprehensive plan, natural resource component that defines prime farmland soils, says that the prime farmland soils is based on the limitations imposed by irrigation, drainage, and flooding, and then it lists all 4 types, which includes ones that require irrigation and drainage. it's saying all four categories are within the heading of prime farmland for our county, the way the comp plan is currently written. So as much as I agree with the frustration about having to deal with the NRCS map and these definitions, based on the way our rules are currently written, prime farmland if irrigated and prime farmland if drained is by definition prime farmland, because that's the way this component of the comp plan is written. And so it's my position that the position represented by Mr. Linscott is not accurate to what our comprehensive plan currently says. Therefore, I agree with staff's position that we have to look at that one soil classification and say that it is prime farmland. I will look back on the other 2 points that were raised for the reconsideration when we look at characterized by slopes steeper than 30%. I've spoken in the past to this, and I'll be really clear. The way I interpret if something's characterized by slopes steeper than 30% has nothing to do with the percent of the property that contains those steep slopes. It has to do with how it impacts the use of the property. Because when I read 12-323 rural district, part of what it talks about under A3 is encouraging conservation development configurations that create permanent open space or farming areas. I'll put emphasis, protect sensitive environmental features, reduce infrastructure costs, and/or enhance recreational opportunities. So I interpret the protect sensitive environmental features and to reduce infrastructure costs to then flow into why it says that the lower density development should be ones that are characterized by slopes that are steeper than 30% because of the impacts and costs that can be associated with them. So that's been the position I've held in these hearings, and I will consistently hold. However, given the additional information that was presented with the reconsideration, with the information that was presented with regard to there being existing access, and I can see zooming in and looking even more closely at the LiDAR layer that the county has on the GIS, I can see where that existing cut does show up in the mapping, and so I can see where you have access through that area in a way that I believe, per your plan, would not compromise the idea of being able to protect sensitive environmental features and reduce infrastructure costs. So I'm going to change my original position on that and say that I believe that that would be met, and therefore I don't see the characterized by steep slopes to be an issue for this parcel based on what's proposed. I want to clarify, I'm not changing how I interpret characterized by steep slopes. I will consistently do that in the future. I'm saying this particular parcel with the additional data that's been presented, in my mind, that's no longer an issue. However, I cannot agree that it does not contain prime farmland soils. I believe it does based on the way section 3.2 of the natural resource component is written. And so because of that, I have to say that it qualifies only for the R10 criteria.
Mr. Chairman, for the record.
I'm sorry, this is board deliberation.
I want to know if you could read the resolution number that you read for the comprehensive plan that you quoted.
This is still.
This is just board deliberation, so again, the current comprehensive plan natural resource component, section 3.2, prime farm soils, it includes all four of those categories. And so my position is that I agree with the staff report indicating that we should consider that soil that's on a portion of the property to be considered prime ag soil. That's the only way I can interpret it.
I think that I'll just reiterate for clarity also regarding the standard for Rule 5 versus Rule 10. And for Rule 10, you have to meet one of the standards. And for Rule 5, it has to not meet a criteria for Rule 10. And because it meets a criteria for Rule 10, it cannot be Rule 5 is the position. And I'm taking the position of even if I remove the slope issue, it's the soil that holds me on the 10 because I think it's open to an interpretation on the slope aspect. And I think Commissioner Domke has made some valid arguments regarding what was presented with respect to slopes. I guess I took an easier way of saying if I just removed it altogether, what is left in the 10 standards there, so.
And I appreciate that. I just want to be clear.
No, I
because
appreciate that
The point
'cause it
being raised was, are we
explains it.
being consistent? And are we meeting people's constitutional protections? And I absolutely care about that. And I want to be clear why I'm taking the position that I am. I don't want to be in any way vague about it. So I appreciate that additional information. It did change my mind on the slope condition, but I just simply can't agree with what has been presented about saying that it is not classified or considered based on Bonner County's rules to be prime ag soils. And I have to be able to check that box and say I followed that rule. So as much as I value and appreciate what you're trying to do on the property for your family, because I completely support that idea, I have to be able to say that I followed our county code, and I don't believe I could. Is there any additional board deliberation? Commissioner Corn, do you have additional deliberation, sir?
One of them's mute. Oh.
Can you guys hear me okay?
Now we can.
Okay. I disagree, obviously. I lean a little bit more toward, protecting people's rights and private property rights. I don't think it's our job or the government's job to run people's lives. If this does contain, because we don't have any substantial proof other than the map when they flew over decades ago, that it does contain prime ag soils. And if it does, it's 20% or less, which is still going to be intact. If this is allowed to go to a roll 5, it will still be all in one piece. It won't be divided by the two. So that can still be farmed if the applicant decides to do so. So that being said, I am going to disagree with the two of you, but that is fine. And I would go ahead and call the vote.
Before we call the vote, I want to comment on the property rights comment because the rights of the property exist. A zone change request, you can ask for a change, but there's not an inherent right for that. And so it shouldn't be seen as the board has an obligation to make sure that we're paying attention to that when we're making a decision. So this isn't a position against someone's property rights. And I think that the tail end of the comment that said it's only 20%, that's actually not what I'm allowed to do. I'm supposed to say, does this parcel contain it? It's not to do, and actually the comment made by Commissioner Corn is actually in opposition to what was presented by the applicant because it wasn't about a percentage or any of that. It's does it contain it? That's what the BOCC says. And it's not for me to say, well, you can still divide it and that portion will contain that. It's does the property as it sits as a 10 contain that soil? If it does not, per our current rules, meet the guideline to be 5. That's all that I can do. And to do anything other than that is actually walking into the door that Mr. Linscott puts forward of, that's me making an arbitrary decision versus me following what's put before me. And so I accept a disagreement amongst board members on how we process it, but this isn't, I'm intentionally not making a decision about anything other than that table said, does it contain it? Yes, it contains it, or does it not contain it? That's what my obligation is. And it's not me taking away someone's right or not taking away a right. All of the rights of the R10, that's what was purchased, that's what the individual has. If it changes to 5, then that's what they would have. I hear that often where people say, if someone doesn't get what they request, that it's implies as if a right is being taken, and that's just not the case here. And I just want to clarify, I'm intentionally not doing a percentage because that's not what the rule tells me to do. That's not what that table tells me. It just says the word contain.
Yeah, I do want to clarify. My position is simply, I have a duty, a responsibility to, as consistently as possible, apply the rules that we have in our county. And that's what I try to do in every one of these hearings. And that's, to me, that, how do we honor and respect property rights? We apply the rules consistently. If we think a rule is a bad rule, we work to change it. That's how we deal with it. And that's what I seek to do each time. So that's the position I hold.
And I would like to say that I do think it is a bad rule. That's why it is being eliminated off of the revised changes coming up. So once those changes take place and get voted on, then this applicant can come back with the exact same parcel with the exact same conditions, and I don't see any reason why it won't be approved at that time.
That may well be the case. Any additional deliberation, comments with the commissioners before someone would like to make a motion?
None from me.
So Commissioner, oh, I'm sorry, Mr. Korn, go ahead.
I was saying none for me.
Okay, sorry for the interruption. I do want to make sure that we're capturing for staff's benefit that we're addressing the biggest two concerns, that we have an agreement on the two things that the applicant brought up in their reconsideration. Because in their reconsideration, they brought up the slope and the soils. I think we've gone over it before, but I think it would be better to have a position from the board, at least the majority of the board, to make a determination on those two things. Since they did not bring up the rest of the staff report, those are the only two things that they are contesting in the decision. So I might defer to Nate on this, but in a reason statement, if this does go to a district court, that we would, I believe that the reason statement from before would stand, but there would be a new reason statement to make new findings on the contested facts, because that is a part of 67, 65, 35 that requires that in the reason statement, is that the board considers contested facts brought up during the hearing.
I think that's a more thorough process, and actually there were 3 points of contention in the reconsideration letter that were raised. So I'd be happy to summarize what those are and then offer my position if the rest of the board wants to agree or disagree. That would keep it simple.
I think that will keep it simple and clearly stating, we'll have some deferment, and then maybe we just go around the table of position argument so that it's clear, and then we'll make the motion that addresses the full at the end. Can I ask, nope, go ahead. I think we're okay.
Okay. So of the 3 items that were described in the appeal letter or the letter requesting reconsideration, it indicates that the board's findings misapplied BCRC 12-323. It relied on standards not found in the ordinance and mischaracterized the soils evidence in the record. Item 1 was slopes, misapplication of ordinance language. It quotes where the ordinance states characterized by slopes that are steeper than 30%. And so it disagrees with the interpretation of the term characterized. I will restate that it's my opinion that characterized should be defined by looking at 12-323A3, where it talks about protecting sensitive environmental features and reducing infrastructure costs, which is why I believe BA that talks about characterized by slopes that are steeper than 30% is included. I see a direct link between those, and that's how I apply that part of the code when considering the term characterized. I'll also state that when we look at the definition of the term, we have to specifically use what county code states, which is Merriam-Webster's Collegiate Dictionary, 11th edition, which I believe is slightly different than what was presented in the letter. But more importantly, I will say that I have changed my position because based on the additional information presented by the applicant, I can see where there is a break in the steeper than 30% terrain, which allows access through that area to to the southern portion of the property, and therefore I believe that the property is not characterized by slopes steeper than 30%, as I understand the intent of BCRC 12-323.
So I came about the question in a different way.
Okay?
Because I did not find that the original decision misinterpreted. I believe that additional information was given in their appeal process that warranted a different decision on the appeal process, but that in terms of characterization of slopes in the original hearing, that information wasn't presented, and it was factual that there were slopes, and characterization is open to interpretation. I think that the applicant took the decision and they reviewed it and did additional work and presented that to the board, by which it compelled a different position on what characterization of the slopes would be. And so I found that in as much as I could argue that I could give or take that characterization, that it wasn't a misinterpretation as much as additional information through appeal could be put forward to compel a different answer. Even though it means the same, it is slightly different, because I'm saying that I don't believe that the board decision was incorrect at the time it was rendered. I believe additional information warranted a different outcome on that topic.
I concur with that. Commissioner Corn?
I'd like to say that I never characterized it by having slopes steeper than 30%.
Thank you, Commissioner. The second item in the reconsideration or appeal letter is the geotechnical ordinance already protects against slope hazards, and it describes the ordinance 12-323 that was adopted in 2008. My position on that is that it's not applicable, because that has to do with when somebody is seeking a permit in order to execute work on a parcel, not about the zone of a parcel being reconsidered or having that zone change. So in my mind, yes, that is absolutely a protection for if or when slopes that are steep exists, in order to determine if it's safe to build on such slopes and in what manner. However, I don't think that's applicable in this case, and it was certainly not part of the board's original decision. So it's I agree with the reference that if permitting were sought in order to construct on the property, that would be potentially applicable if you're going to seek to build in such a slope. But I don't see where it's relevant to this decision.
I concur with emphasis on the fact that that was not what was presented in the original hearing, and further that it's not applicable to how we would characterize a slope.
Commissioner Corn?
I have no issues.
All right, and then the third and final element was soils. The contention indicating that cell emission unit 50 is not prime. And so we know that we've had the information presented with the 2005 data that was presented by the applicant, as well as the ordinance 12-323 that was adopted in 2008. They also presented some of that dated map information. And then there was the 2022 natural resource component that they also spoke to. And so that stands in opposition to staff report and staff opinion on how to interpret the definition of prime ag or prime farmland soil. And I go back to and reference the current adopted version of the natural resources component of the comprehensive plan. And in looking at that, when we go to section 3.2, prime farmland soils, it specifically indicates that prime farmland soils is based on the limitations imposed by irrigation, drainage, and flooding. And then it further lists all four types, being all areas are prime farmland if irrigated, prime farmland if drained, prime farmland if drained and protected from flooding or not frequently flooded during the growing season. Because our comprehensive plan includes all four types of soils to be considered prime farmland soils, and it indicates that some of those soils do contain limitations that are imposed by irrigation, drainage, and flooding, I believe that the conclusion of the staff report on this topic should be upheld.
I agree with that, and I would emphasize that the applicant presented a narrow scope of the definition of that soil type, removing the elements of the comprehensive plan by which the board actually has to review in totality. And when you expand that, as discussed in this deliberation, that it's clear that it does contain that element on the property, which doesn't allow it to be shifted from an R10 to an R5 simply because it contains it on the property itself.
Commissioner Corn?
For me, it is not clear that this soil type exists on this property. As I stated before, we've had applicants that showed the mapping, the soil mapping, that it was on that parcel, and the applicant went and did actual soil tests and proved our maps wrong. Therefore, I cannot consider our maps to be that accurate. And if I had to side with the government or the people, I would side with the people. So in this case, I'm going to say that it does not, I don't have evidence that it contains prime ag soils.
Okay, and just to clarify, since BCRC tells us that the way we determine whether or not a property contains such soils is to use the NRCS maps, I will rely on those maps unless further evidence is presented to the contrary.
I will make the comment that it is noteworthy that the definition of what is prime ag, prime farmland, there was a limited scope that didn't include what our current comprehensive plan requires the board to make a decision based off of.
Okay. So those are all the 3 points that were raised in the appeal letter requesting reconsideration. And so I believe we have thorough deliberation for a reason statement decision letter. And with that, I'll entertain a motion.
I move to uphold the board's previous decision and deny this project file ZC0003-25 requesting a zone change from Rural 10 to Rural 5 based upon the following conclusions to include the updated worksheet that the board just completed. Conclusion 1, the proposal is in conflict with the policy of Bonner County Comprehensive Plan. Conclusion 2, the proposal was reviewed for compliance with Title 12 Bonner County Revised Code and was found to not be in compliance. Conclusion 3, the proposal is not in accord with the purpose of the Rural 5 zoning district provided at Chapter 3, Title 12 Bonner County Revised Code. The decision is based upon the evidence submitted up to the time the staff report was prepared and testimony received at the hearing. I further move to adopt the reason statement as discussed, and I'm going to be specific to kind of say both reason statements at this hearing because we pulled the first one forward. In deliberation at this hearing and the analysis as set forth in the staff report or as amended during this hearing, and direct planning staff to draft the reasoned statement to reflect this motion as set forth in Idaho Code Section 676535, specifically requesting that staff, when you do the report, that you hit all 3 items that the appellant brought with all 3 commissioners' responses to each item specifically in that statement. Have the chair sign and transmit to all interested parties. This action does not result in a taking of private property. The action that could be taken, if any, to obtain the zone change is to file a new application with the planning department and meet the standards required by Bonner County Revised Code or pursue such remedies as may be applicable at Title 67, Chapter 65, Idaho Code.
I'll step down in second. Any further board deliberation? Commissioner Corn?
I have none.
Commissioner Williams has none.
Roll call vote, please.
Commissioner Donkey?
Yes.
Commissioner Williams?
Yes.
Commissioner Corn?
No.
Motion passes. It is 10:11 a.m. and this hearing is adjourned.